Would you ask Lord Wharton to come back in, please?
Okay. 68. Let's go to 68.
Right, Lord Wharton, ready to carry on, I hope?
Absolutely.
Thank you very much. Yes, Mr. Millett.
Thank you, Mr. Chairman. Lord Wharton, I'll ask you now about a different topic, namely the APPG and the correspondence between your department and that group. Now, the APPG, as I'm sure you're aware, stands for All-Party Parliamentary Fire Safety and Rescue Group. Yes?
Yes.
And you, I think, would have been aware of that group during your time as a minister.
Yes.
Yes. Were you aware of which officials were drafting responses to the APPG?
I don't recall at the time having been aware of which officials would draft the responses, no.
Right. Did you know that often, not always, but often it was Brian Martin, a G7 official?
I don't recall knowing that.
Right. You don't recall? Does it mean you don't recall one?
I mean, I don't think I know, but it's not impossible that at some point it was mentioned to me. I don't recall that it was something I was aware of.
Right. I mean, if you had a question on the substance of the correspondence, who would you contact?
My private office.
And who would they contact?
I don't know.
Did you not want to know?
Well, they would come back with a response if I had a question or an amendment.
Okay. What, from some unnamed official? You didn't care to?
Well, I wouldn't put it like that. I mean, as I say, my main point of contact, the person I most frequently would speak to was Bob Leadsom. If there was an issue with a piece of correspondence, I would make an amendment, send it to my private office, and then it would come back either appropriately amended or with reasons that something else should be done with it.
Right. Did you ever feel that you weren't able to challenge either the APPG correspondence or the replies drafted on your behalf?
No.
You never felt that?
I didn't feel that.
Okay. Now let's go to CLG 3019298. I'm showing you here a letter from Sir David Amos, the late Sir David Amos MP, Member of Parliament for Southend West, dated the 10th of September 2015, received in the department on the 16th of September 2015, as you can see. So that's the day after, as a matter of chronology, the day on which you received the submission, which was the 15th of September. Now, the first paragraph, Sir David explains that the group had met your predecessor, Stephen Williams, who had acknowledged that there were important fire safety matters worthy of full consideration during the review of ADB, as you can see, and the review of ADB had been set out in the Secretary of State's letter to the coroner after the inquest. I'm summarising.
Yes.
And he goes on to say this in the next paragraph. The group felt that 3 of these matters had significant life safety implications. ND were therefore of sufficient priority to be dealt with immediately ahead of the review, thereafter leading to a publication of a revised document in 2016 to 17. The Minister, however, was not willing to bring the programme of work, which had already started, forward. As chairman of the APPG, I kindly request assistance with the following 2 issues. And then he goes on to cover those, which I'll come to. Did you appreciate that the APPG felt, and were telling you in September, that they felt that the current version of ABD had significant life safety implications?
I don't recall exactly what I felt when throughout my time of the engagement with the APPG, but I certainly will have seen the letters and was aware of the breadth of their concerns. Yes.
Yes. I should have pointed out the fact that you are the addressee of this letter, and I was assuming that you'd read it at the time. Would that be fair?
Yes, I would see it when a reply had already been drafted, and it would come in my box for signature or to be amended. The reply, that is. So I would only see it with a reply.
Is that right? You wouldn't see it and then send it out and ask people?
No.
To address the questions you felt needed to be addressed?
No, my private office would send it to the relevant team to get a response, compile a response, and would put it in my folder for either signature of the response so that they could send it, or for any amendment I would then choose to make.
I see. Right. So is this right? When it came back to you, did it have these stamps on it? Minister JW... Sorry, you can't see that, actually. If we can scroll to the top of the page. You can see some stamps. Minister JW, subject APPG, document B, building regs, official Bob Leadsom, Brian Martin.
I don't remember.
Would that be normal, though?
I don't recall.
You don't recall the process?
I don't recall the stamp, whether there were stamps on the letter at the time it came to me, no. I know that I would receive a proposed reply for signature and the original letter together in a pack.
Right. Do you recall that you had been told the previous day, in fact, pretty much what the second paragraph of this letter says?
I don't, because I don't recall exactly what the chronology of these documents finding their way to me would have been. As I say, I remember the letter, but I don't remember exactly when I saw it and how that timeline interacts with other documents that I saw, and how I felt about that at that time.
Now, Sir David goes on, as you can see at the foot of the page, if we can go back to that, please, to ask for confirmation in paragraph 1 as follows. Please can you confirm that the review of approved document B to the building regulations as set out in the Secretary of State's letter to Her Honour Francis Kirkham CBE following the Lacknell House inquest will continue, leading to, as I mentioned above, a revised document being published in 2016 to 17. Did you note that at the time?
I don't recall.
Well, if you read it, can we take it that you did?
No, I can't recall. I read it. I don't recall what I noted and didn't note at the time.
No, perhaps I've not framed the question clearly enough. That if you read it at the time, then you would have noted it all at the time.
If I read it, I would have read it. I don't remember whether it had a particular significance or salience to me at the time. I remember receiving the letter, and I remember I read the letter.
Now, he goes on to say, a similar commitment was made in a Westminster Hall fire safety debate, 3rd of March 2015, relating to the case of Sophie Rosser. I'm attaching copies of the Secretary of State's letter and the Hansard record of the Westminster Hall fire safety debate into the case of Sophie Rosser for your convenience. Now, can we take it from this that you knew that Stephen Williams had made the commitment to deliver the revised ADB by 2016 to 17 by that time?
I don't recall whether I knew that specifically at that time. I suspect it is unlikely I read the full Hansard transcript, if it was even provided to me. I think it's more likely only the letter itself would be provided to me in the pack. But I was aware that this commitment existed, as we have already discussed.
Right. Let me see if I can lay this to rest. Can we go to RKI 6055, please? Now, this is a Fire Sector Federation overview from you, I think. Is that right?
From me?
Well, it says from On Admin Sec for Building Regulations, Minister, James Wharton MP. Or at least it has to do with you.
It's for me, yes.
It's for you?
Yes.
Right. Did you read it?
I don't recall.
Very well. It hasn't got a date on it, so I don't know whether you can assist us with it. But when do you think you first saw it?
I don't remember having seen this document at the time. It doesn't mean I didn't, but I don't recall it.
All right. It says in the second paragraph, indeed, your predecessor a year ago wrote to the leader of a local authority stating, we do have plans to review Part B of the building regulations and expect any revisions to take effect in 2016 to 17. With this in mind, we have commissioned the Building Research Establishment to look at a number of issues which will provide an evidence base for a future review. Given work is now underway, I'm not inclined to consider issues in isolation and in advance of this wider work. He reiterated this at the Sophie Rosser adjournment debate in Westminster Hall in March last year, when he cited a revised document to be completed in 2016 to 17, which would see the guidance simplified where possible and updated whilst revising the technical content at the same time. Stephen Williams also wrote in similar terms to our chairman, saying, I do acknowledge that the matters to which you refer are worthy of full consideration, and I've asked my officials to ensure that they are included in the ongoing review. Now, were those matters that you knew or knew of in September 2015?
As best I recall, I was familiar with the matters in an overall sense, but I don't recall this particular document, and I'm not sure how familiar I was with the Sophie Rosser adjournment debate. I don't remember that being of particular prominence in my mind at the time.
Right. Did you know that Sophie Rosser was a young architect who had died trying to rescue her fiancé from a fire in a development in Docklands, and whose inquest had happened in September 2014, where the coroner had highlighted a number of fire safety problems with the building, self-closers, inadequate smoke ventilation, and only one fire and risk and FRA, fire risk assessment, since 1997. Anything like that?
I think I had a very high level awareness of the issues around it, but I wouldn't. I don't recall having known the detail in those terms. No.
Right. So you see, it was referred to, as I showed you, in the letter to you that Sir David had sent you on dated the 10th of September. Were you not interested to understand what had happened to Sophie Rosser and why that was relevant to anything to do with you?
I don't recall exactly what steps I took at the time, but I don't remember having received a copy of or read the Hansard of the adjournment debate.
Did you not want to see it, given that it was something Sir David had raised?
I don't recall exactly what questions I asked or what full understanding that I had at the time, but I didn't read the entire Hansard of the adjournment debate, no.
Now, there's a reply to Sir David's letter at CLG 30194454. It's undated, as you can see, but we understand from other evidence that it was sent on the 23rd of October 2015. Would that be about right, to the best of your recollection, Lord Wharton?
It would seem to make sense in line with the timeline of the previous letter, yes.
And if we look at it, in the second paragraph, you say, and I'm so sorry, forgive me, if we go to the bottom, we can see your name is at the bottom of it. If you scroll to the bottom,
yes.
There's your name. Now, go to the second paragraph, it's still on the screen. I have yet to agree a detailed work plan for building regulations with my officials, you say. That's the first sentence. Now, just pausing there, here we are, late October 2015, after the coroner's letter sent in March 2013, so some 2.5 years later, and, as you say, a detailed work plan had not been agreed. Did that fact in October 2015 not cause you to go to Bob Leadsom or any other official with responsibility for the building regulations and approved document B and ask him, well, what is the detailed work plan? Where is it?
I don't recall whether I asked that specific question, but I did on a number of occasions raise concerns and frustration with delay to the progress of addressing these issues.
When you received the 10th of September letter from David Amis, was this the reply and draft that had come with it?
I would assume so. It looks like it, but I can't remember the exact detail of the letter that I finally signed on that date. It perfectly plausibly, yes. Did I notice it? I note it's not a signed copy, but I would think it is.
When you received the draft, how would you go about making amendments on it if you were going to make any? Did you make them in manuscript?
Manuscript amendments, usually, yes. Unless there's something very substantial to change, in which case I might speak to my private secretaries and not literally dictate word for word, but have a more detailed conversation about changes. A letter like this, I would expect to make manuscript amendments.
And is that because they didn't come to you electronically? They were presented to you as physical hard documents?
That's correct, yes.
And were they in your box?
Yes.
I see. So you would you'd come across them in the course of your ordinary box work?
That's right.
Right. And you'd make manuscript amendments and then you'd put them back in your box for your private secretary to take away?
Yes.
And then would you see the final version? Presumably you would, with your
Yes.
amendments in it.
Yes.
Do you remember an occasion when your amendments got debated between you and the relevant officials?
No.
When you signed this letter, did you go back to the 15th of September submission, which had only been with you for 4 weeks or so, to double-check what had been done to progress the review?
I don't recall whether I asked about it. As I say, on a number of occasions, I know I raised the issue of the delay. Whether I did it specifically as a result of this letter, I don't remember.
Right. Now, we now learn that you attended an informal lunch with the APPG the following month, 26th of November 2015, and we have a note of that. We also, I think, see that two days before that lunch, on the 24th of November, you were provided with a briefing note for that lunch by Brian Martin at your request. Can we just go, please, to CLG 100007717? This is an email of the 24th of November 2015 to you from Brian Martin, copied to Bob Leadsom and others, including Richard Harrell, Peter Schofield and Sally Randall. As requested, see attached a briefing as follows. Summary, Sir David Amess MP, Chairman of the All-Party Parliamentary Fire Safety and Rescue Group, APPG, has invited you to an informal lunch with some members of the group, and Brian Robinson, Chairman of the Fire Sector Federation. Routine. Meeting will take place on Thursday, the 26th of November 2015 from 12 p.m. to 1 p.m. in the Barry Room, House of Lords. Recommendation that you, 1, approach the meeting in, quotes, listening mode, close quotes. 2, note the lines to take attached at Annex A. Now, you may or may not recall receiving that email.
I wouldn't receive that email. That's to my private office. But the substance of it may well have been put into a cover note on the submission. I don't remember exactly.
Yes. And let's go to CLG 100007718, which is the document attached to this email. There's the first page. It's from Brian Martin, cleared by Bob Leadsom, Sally Randall as well, to you, dated the 24th of November 2015. All-Party Parliamentary Fire Safety and Rescue Group lunch meeting 26th November 2015. And then there's a summary, which is exactly the same as in the email we've just seen. The timing, the same. Recommendation, the same. And the lines to take are in Annex A, as you can see. And if we go to page 2 in the briefing note, or submission, page 2, paragraph 7, under the heading Likely Topic of Discussion, it says this. In 2013, the inquiry into the 6 deaths in the fire at Lacknell House recommended that the guidance in approved document B should be simplified. Eric Pickles' response to the coroner set out his intention to review Part B during this Parliament, and this would include simplification where this was possible. A copy of the letter is at Annex C. Now, Annex C is at CLG 100007733. Let's just have that up. There it is. It's Eric Pickles' as it turns out, 20th of May 2013 response to the coroner's Rule 43 letter of the 28th of March 2013. Would it have been your usual practice to read briefing notes and their annexes such as this?
Yes.
I think you tell us in para 16 that it was. Now, if we go back, please, then, to the note at CLG 100007718, page 2, paragraph 7, you see there that he says, in the penultimate line, this would include simplification where this was possible. What did you make of the where this was possible qualification we now see here?
I don't recall having particularly picked up on it as an issue.
Right.
It seems an unnecessary statement of fact, but I mean you can't simplify where it's not possible. But I don't remember having picked up on that as a particular salience.
No. Did that therefore not cause you to stop and say, well, hang on, what is this department actually committed to? Is it just simplifying language, or is it simplifying language only where possible, or what? Did you not ask that question?
I don't remember asking that question specifically in relation to this paragraph, but as we've seen, I'd received a number of, or by this point had received some, and throughout my time there received a number of submissions describing what work was proposed and ultimately planned.
Now, following the meeting, you were provided with a note of the meeting by Brian Martin on the 30th of November. Let's go to that. It's at CLG 100008066. And we can see from the heading that it's entitled All-Party Parliamentary Fire Safety and Rescue Group Lunch Meeting, 26th November 2015. And at the top, it says who is present, the purpose, invitation, where it takes place, and who is in attendance. You can see a cast there, including Sir David Amess, Mary Glindon, Pete Aldous, Ronnie King, and others, including Brian Martin and Sarah Morgan from the department. And then Sir David Amess, MP, chairman of the all-party group, introduced the group and flagged that they had not been able to persuade previous ministers that a review of approved document B was urgent. So just pausing there, do you remember Sir David stressing the urgency of the work?
I don't remember specifically. I find it entirely plausible. I think there was some discussion of document B at that meeting, but I don't remember exactly what was discussed, and I don't recall having read this note at the time.
When you say there was some discussion of approved document B at that meeting, was that not the totality of the discussion, or were there other things discussed?
No, it was not. I remember saying I've had the opportunity to read this document as part of this process, so I don't recall having read it at the time. My recollection is that there was a significant focus, for example, on the issue of retrofitting sprinklers, which I don't think is captured in this document. So I'm assured that approved document B was discussed. I think that insofar as it goes, this document probably captures most of that, but I don't think this is a entirely comprehensive note from what I recall of that meeting.
And if you look at what you said at the bottom, in the two paragraphs there, you say that you did not want to do work with building regulations, did want to do the work with building regulations, and hoped to set out your plans in the early new year. And then it says he welcomed comments from the all-party group and the Federation. However, he was clear that the principal objective for any work would be simplification and the reduction of red tape. Do you agree that that's what you said?
I don't recall. And as I say, I don't recall seeing this note at that time.
Well, have you any reason sitting there now to think that that was a recording of what you said?
No, but I think that the note may not be a fulsome record of everything that was said.
Well, it's not verbatim, and I don't think it purports to be, but does it have you got any reason to think, sitting there now, that it doesn't capture the gist of what you said with a reasonable degree of accuracy, Lord Wharton?
I think it may not be complete. I think for an hour-long meeting, as I've mentioned, the issue of sprinklers, which I notice is not in this note. I don't think this note captures in total what was said. I don't dispute it's quite possible that I said simplification and reduction of red tape would be part of the aim of what we're going to do. I don't recall having said it was the principal objective of work, and I don't think that this note fully captures everything that was discussed at that meeting, accepting it's not verbatim, but still I think there are omissions even from the memory that I have 6-7 years on.
He goes on, he raised a concern that a debate on a significant change in scope for Part B beyond life safety could significantly delay progress and should be raised as a separate issue. Did that option, namely prioritising the review on life safety issues, get picked up as an option, either at this meeting or in its aftermath?
I don't recall.
Do you remember whether Brian Martin said anything at this meeting?
I don't remember Brian. The only reason I'm aware that Brian Martin was at this meeting is because this note tells me so.
I see. So you have no independent recollection of Mr. Martin or his presence or whether he said anything?
That is correct, which would lead me to believe he probably didn't say very much of anything, but I don't recall in detail.
Now, if we look at the bottom of the page, in the previous paragraph, you had said that, or it's recorded as you saying, that you had hoped to set out your plans early in the new year. That's in the penultimate paragraph, I'm sorry, just after where we see your name.
Yeah, I can see.
Now, if we get on that to CLG 100077731, this is Annex A to the submission that you had received on the 24th of November, so 2 days before. And this is lines to take. And you'll recall that that was referred to in the submission.
Yes.
Yes. And it says here, in the first bullet point, we have not yet agreed a detailed work plan for building regulations. What we do with the fire safety aspects will need to align with any other work we are doing. I hope to set out our plans early in the new year. So, is it right that what you said in the meeting, or are recorded as having said in the meeting, according to the note, was lifted from Annex A? Not verbatim, but the sense of it.
That would appear to be the case, yes.
Did you ask Brian Martin, who had provided you with Annex A, here as you see, or Bob Leadsom or anybody else, what was the thinking behind the early New Year time frame?
I don't recall.
Now, at the time, at the end of November 2015, the 15th of September 2015 submission had scheduled publication of the discussion document for later in 2015. We saw that earlier this morning together, didn't we? Yes? Yes. Now, the 10th of November submission had scheduled publication of the discussion document for early 2016. Yes?
Yes.
Yes. So, did you query this aspect at the time?
I don't recall.
In the second bullet point, it says, as you know, the department commissioned some preliminary research on some technical issues and has now commissioned a usability survey. What did you know about that research on the technical issues?
I don't recall knowing anything about the research on the technical issues.
Did you ask?
I don't recall whether I did or not. I recall the meeting and remember parts of it, and this document is familiar to me. Beyond that, I can't remember what specific questions I asked arising from that, or specific issues that I discussed further, either with my private office or with other officials.
Do you remember asking whether these technical issues address matters of life safety, fire safety?
I don't recall.
If we go back to your first statement, please, page 12, paragraph 27. You say in that paragraph, 5 lines down, it's towards the end, the right-hand side of the paragraph. I note from the readout that the APPG expressed the opinion that the review of approved document B should not be limited to clarification and simplification, but rather should be a wholesale review. I made clear that the principal focus of the review would be on clarification and simplification. Now, the readout there, I think, is a reference to the post-meeting note. And correct me if I'm wrong about this, Lord Wharton. Let's have it. It's at CLG 100008066. That's the same document?
Yes.
Right, that's what you mean by the readout, I see.
I think so, yeah. Yes, it is,
Right.
yes.
Now, then let's go back to the penultimate paragraph, pre-penultimate paragraph, last line, clear that the principal objective for any work would be simplification and the reduction of red tape. Did that principal objective, as you understood it, involve the technical issues requiring attention as a matter of life safety?
I couldn't with certainty tell you what is meant by that.
Right. Can you help? What was covered then, perhaps in more general terms?
As I say, I have a limited... Sorry.
What was covered by the phrase simplification and the reduction of red tape?
I don't recall the specific details of the discussion at the meeting itself. I would say that I can certainly... I think at the time I would have seen simplification and reduction in bureaucratic burden as a positive thing to do and would want to have pursued that as part of the process. I think that the where I would take issue with this is that if were one to infer from it that is to the exclusion of anything else, which would not have been my intention. And indeed, in all of the discussion that I had, I think one of the challenges that led to, or one of the causes of delay, was actually that this was a piece of work that was broadened out rather than narrowed in order to ensure that it was comprehensive. And at no point did I recall, refuse that process by which the department advised me we should make it more comprehensive and take in the round.
Did you make it clear at the meeting that a full review of ADB would be included in Phase 2 for delivery in October 2019, along with the review of building regulation policy more widely?
I don't recall. I would be surprised if I set out timetables which had not been published to the meeting. It wouldn't be appropriate or wise necessarily for me to have done so. But I do recall having sought to reassure the group that the views that they had would be taken into account, and that I would do what I could to ensure that the department took those views seriously.
Why didn't you tell the meeting, on what you knew by that time, that the target date for 2016 to 17, whatever that meant, as promised by Eric Pickles to the coroner, was now most unlikely, if not impossible, to be met.
I don't recall the detail of the discussion around that. I can't say whether that came up and what I said. As I say, I don't think this note is comprehensive. I don't dispute much of the information in it, and I have only limited memory of the actual discussion in this particular engagement.
Right. Can we take it, though, that if you had told the meeting, David Amos particularly, that the 2016-17 deadline, whatever that meant, was now either very unlikely to be or incapable of being met, then David Amos would have reacted in some way?
That would appear logically true, yes.
You have no recollection of telling those present at this meeting that on what you knew, that deadline would not be met, do you?
But that's correct.
And the note does not record your saying in clear terms or in any terms that deadline is not going to be met.
Again, correct. I mean, I would clarify, it would be not necessarily appropriate to pre-announce decisions that may not be public to an all-party parliamentary group meeting.
No. Now, let's go to the next letter that comes from the APPG, CLG 1000780. This is a letter from David Amos to you a few days later, dated the 1st of December 2015. We can see it comes from the APPG. It's signed by Sir David, as we can see later, addressed to you. And it thanks you for coming to the lunch the previous Thursday, as you can see from the first paragraph. And if we look at the second paragraph down, Sir David says this: over the past 2 years of correspondence between your predecessor, Stephen Williams, and myself, the group has felt continuous frustration over dismissive responses to its well-founded and justifiable concerns, whereas yesterday we did find a more considerate tone to the discussions, which was welcomed by all. And then he goes on. I'm sure you received a strong, clear message from yesterday's meeting that the existing guidance in approved document B to the building regulations last updated in 2006 is badly in need of revision, or, as the group suggested, replacing it with something else that is all-encompassing, given that the original building regulations were introduced in the 1960s, having developed from a series of bylaws based on national models with the regional variations. The origins of some of these requirements can be traced back to the redevelopment of London following the Great Fire in 1666. Now, just pausing there, you say, let's look at your second witness statement, page 10. And if we can go there, please, to paragraph 23. You say, having quoted from the letter and other parts which I haven't read to you, this did indeed reflect the strong, clear message of the APPG that I received at the meeting, that the guidance was out of date and badly in need of revision, the regulations themselves were incoherent and in places outmoded, and that ideally a unified, all-encompassing system of regulation should take their place. So can we take it from that the urgency expressed at the meeting was not lost on you?
Yes, I think the position of the APPG was clear.
Yes, and
in that respect.
Yes, and life safety. You appreciated that work on approved document B was urgent precisely because it concerned matters of life safety.
I appreciated the view of the APPG was that they wanted this to be something that was done as soon as possible, and they had a very strong opinion on the matter.
Did you not share that view?
I didn't necessarily have a stronger view, and I was receiving advice from officials in the department that indicated that, as I said earlier in my evidence, the system was working well, but that work did need to be undertaken to make amendments and improvements, and plans were being put in place to do that.
Well, you say you didn't have a stronger view, but did you not either share or have sympathy with the view and the urgency of the view that Sir David was expressing, that there were defects and outdated aspects of approved document B and the building regulations more generally, some of which went back to the 17th century, which now urgently needed revision precisely because, if not revised, people might die?
I received a very clear message from the APPG members on this issue, yes. I took advice from officials on it and was assured that generally the system was working well, but that the review was indeed proposed, and we'd had previous discussions of it, and I had submissions on that, and there was a plan for there to be a review.
Right. Now, did you get the impression from your officials that Sir David Amos's and the APPG's expression of urgency and the reasons for it were exaggerated, unnecessary, and over the top?
I don't recall any of those terms being used, but I did receive advice from officials that ran contrary to the strong view that the APPG had.
Right, so your officials were telling you, were they, that Sir David Amos was overstating the case for urgency, and there wasn't such a risk to life safety as he was making out? Was that how you understood the advice, the gist of the advice?
I would say
from
I don't
your
remember
officials?
my officials ever commenting on Sir David himself, nor would I expect civil servants to do so, but the advice they were giving me was in line with the comments that I've already made, yes.
Well, let's be clear. You weren't able to take advice from anybody other than your officials, the body of officials in the department, were you?
No.
That was your sole source of information?
By far the primary source, yes.
Right. And you didn't have an independent view, did you, of whether the APPG's concerns were valid and reasonably expressed, or invalid and immoderately expressed?
No, I did not.
No. So you were entirely reliant on your officials. So can we take it that when you formed the view that in response to the APPG, that view was entirely based on what your officials were telling you?
Yes.
So can we take it, therefore, that your officials were giving you advice to the effect that the APPG's requests to you were overstated and unnecessarily and unreasonably misassessed the risks of death?
I think I don't recall that the APPG had a view, and they expressed it to me. Exactly the terms in which they did that, other than what's captured in the letter, and in terms of the discussion at the meeting, I can't recall in detail. The reason I'm slightly hesitant to agree with that summary is that, yes, part of the message that I received from the department is that things are not as bad as they're conveying, things are working well, the system is a good one. But the second part of that message is we also have a plan that will address and give the APPG the chance to be involved in the process of addressing those concerns where they exist.
Now then, going back to the letter, page 2, please, at CLG 1007860. If you look excuse me, if you look at the first paragraph on that page, it says as follows: today's buildings have a much higher content of readily available combustible material. Examples are timber and polystyrene mixes in structure, cladding and insulation, with internal fire protection usually afforded by layers of plasterboard and use of fire-stopping padding. A plasterboard compartment is often incomplete above false ceilings and becomes imperfect over time through DIY and wear and tear. This fire hazard results in many fires because adequate recommendations to developers simply do not exist. There is little or no requirement to mitigate external fire spread. Now, if we go, having read that together, go to your second witness statement at page 10. Paragraph 24, you say, having cited some of that, in the fourth line, you say, I recall accepting that statement as likely to be accurate. I very vaguely remember raising the flammability of materials with the building regulations team, though this would not have been a technical discussion, but rather along the lines of me asking whether it was a problem and how they intended to address it. As previously stated, I recall being told that these issues would be considered as part of the review. And I'm sorry to do this to you, but can we go to one other paragraph, para 29 on page 13, before we come to the question? And at paragraph 29 on page 13, you say, in the third line, I believe and would expect that it was Bob Leadsom who had told me that the system was working well. For the avoidance of doubt, the words "working well" are my words, intended to summarise the general sentiment of the advice I received. I was informed that the number of deaths from fires had fallen substantially over the years and understood this was considered to be attributable, at least in part, to the building regulations. This did not seem unreasonable to me. So that's where we see the sentiment. Now, did that sentiment there that you've just expressed in that, was that working on your mind when you read Sir David's 1st of December letter?
As I say, I don't remember specifically what I was thinking as I read it, but yes, it will have been. That would be the background against which I would have assessed additional information that came to me.
I see. And you never tested Bob Leadsom on this, on his statistics or on what he was telling you? You just took it at face value?
No, I certainly had further discussions. I think I make reference to that I can't remember exactly when, but I do remember asking about fire spread and fire safety specifically at some point. But again, the briefings that I received were reassuring in their nature and left me with the impression that whilst improvements could be made, there was a process for that, and the system that was in place at that time was an effective one.
Right. Now, I think you were, as you tell us elsewhere in your statements, aware that the concerns raised by the APPG concerned combustible materials in modern buildings. Yes?
Yes, some of them, yes.
And you thought that would be covered as part of the upcoming review?
I believed so, yes.
Now, did you appreciate that the APPG were telling you that the then current version of approved document B provide little or no guidance to developers about external fire spread?
I mean, the words are in the letter. I don't recall exactly what I thought about it, but again, as I say, these were the issues, and the letter were raised with the officials on whose advice I depended, and the advice that I was given was in line with what I've already described.
I'm just seeking to explore with you, really, to what extent you actually understood the gravity of the risks posed by modern methods of construction, the presence of combustible material in external wall structures above 18 metres, and the adequacy of the guidance given to those carrying out the work under the building regulations.
Yeah, I would say I had a limited understanding, not being a technical expert, and I relied on the advice that I was given.
Yeah, and the advice you were given, did that draw particular attention to external fire spread, or was external fire spread just one of a swathe of issues to do with changing ADB or not?
I don't recall specifically. I would therefore, subject to the fact that I don't recall, say it was more the latter than the former of those two statements.
So can we take it that those issues didn't strike you at the time as particularly deserving of your particular ministerial attention?
They didn't stand out as against the general proposal for work to be done on the relevant documents. They didn't stand out specific issues at the time as against the other issues that needed to be addressed, such as we've seen in the documents, the coroner's recommendation for simplification.
Yeah. Now, this letter, as we've seen, was sent to you in December 2015. At that point, as we established earlier today, you had seen the 10th of November 2015 submission, which had explained that the revised documents would be published for external review in the second half of 2017. Yes?
Yes.
Yes, and the revised regulations and approved documents in 2018. Was it your impression, come December 2015, that the issues about the use of combustible materials in modern buildings would be addressed as part of the review to be finalised in 2018?
Yes, I understood it to be a comprehensive process of review, and that there would be a process of engagement. And I specifically remember, and I say I can't remember exactly when I said it, but sort of asking, I suppose, instructing the officials that the APPG should be involved in that process of review. So I wanted specific attention given to the APPG because of the concerns they had raised with me as part of that process.
Right. Now, you, I think, approved the November submission on the 7th of December 2015. Yes?
I take your word for the date.
Well, let's look at, don't do that. Let's look at CLG 1000785. And this is from your office to Greg Clark, 7th December. I think we looked at it earlier today.
Yep.
On this, JW agrees with the proposed programme and next steps. And then we have the bit about the building controls.
Mm-hmm. Yes.
Yes. So can we take it that you knew when you expressed your agreement to Sarah Morgan, and she in turn to Greg Clark, of the APPG's concerns, and that a wholesale review and replacement was what the group sought.
Yes.
Yes. And you knew, I think by then, because you'd been told by Sir David on a letter the week before, that the Building Act itself, so far as they were of the view, was increasingly outmoded, but that a fundamental rewrite would be time-consuming and imply a full review of the entire regulation. Yes?
Yes.
Yes. So in light of that knowledge, why did you approve the 10th of November submission on the 7th of December 2015, knowing what you by then knew and had learnt from the APPG in the interim, that the work proposed would not address those concerns?
I'm sorry, that it wouldn't address those concerns, or that it wasn't sufficiently speedy?
Well, both, actually, since you raise it.
Okay, I didn't appreciate that the work proposed wouldn't address the concerns of the APPG, and indeed I wanted the APPG to be part of that work. My understanding of the work that would be undertaken was that it would be comprehensive and allow for amendments to be made to the building regulations as required, and I was convinced of the need for it to be comprehensive on the basis that it needed to be done properly rather than piecemeal amendments made that may have unintended consequences or not have the desired effect.
Right. So, can we take it then that despite the APPG's requests for urgency, specifically on the matter of life safety, raised with you twice, I think, first on the 26th of November and secondly in the 1st of December letter, both dates 2015, you nonetheless went ahead and approved the submission on the 7th of December 2015, which would have the effect, essentially, of producing a revision to ADB that would not appear until 2018.
On the basis that I understood that was the proper way to undertake the work, yes.
Yes. Now, we've seen, I think, the 1st of April 2016 submission, which is the next one that follows the November 2015 submission. That's CLG 3019344. We looked at that this morning. Let's go back to that again, if we can. Page 2. And on page 2, you can see Annex B, which we looked at Annex C, remember, which was the timeline. The murder mystery novel. But if we go to Annex B, summary of proposed discussion paper, do you recall that the discussion paper was provided to you in order to set out the scope of the review of ADB, yes?
I'm sure it will have been. I don't recall specifically.
Let's go to it. It's at CLG 3019343. 19343. It's called Annex A. That's an error. It should be B. But it is nonetheless a chapter outline of discussion paper. Did you read it at the time, do you think?
If it was provided to me, I would have. It looks somewhat familiar to me now, but I can't remember the detail of it.
Yes, and again, as you said in your statement, as we've repeatedly now examined, you would ordinarily read submissions and annexes in their entirety, such as this.
Yes.
Yes. So I'm going to assume that you did read it at the time. It's only 5 pages long. If we go to page 2, the section relevant to approved document B is there in the middle of the page under Chapter 4, Periodic Review of the Building Regulations. And it says, Part B, Fire Safety. This section will set out our intention for a limited scope review focusing on simplification and specific technical issues. This will help to manage expectations and strong lobbying for expansion of regulation. This will lead to an update of Part B, which will also fulfil last government's commitment to clarify guidance in this part of the regulations. Now, the advice that was given to you was that the APPG's concerns regarding the increased quantity of combustible materials in modern buildings and with the changes made to stop it or regulate it would form part of the review of ADB. Yes?
That was my understanding, yes.
Yes. But there's no reference here to combustible materials, is there?
No, but I would assume that technical issues would cover that. And as I said, I specifically asked officials to engage with the APPG as part of that process. So I would have expected if there was an omission about which they were particularly concerned, it would then be drawn to my attention.
Right. Was it?
But the process didn't begin whilst I was there, so no.
No, so no. And nor is there reference to new technology in construction or external fire spread or cladding, for that matter, is there?
They aren't specifically mentioned, but I would expect that technical issues would cover those sorts of matters.
Given that these were issues which Sir David Amos had taken the trouble to spell out in his 1st of December letter, did it strike you at the time that this particular section might be a little bit short on detail?
No.
It didn't. When you read it, did you understand, did you hark back to the David Amos 1st of December 2015 letter and understand that the review would focus on technical matters, including the use of combustible insulation in high-rise buildings above 18 metres, the use of modern methods of construction, external fire spread, and matters of that nature?
I don't recall what I thought at the time of reading this. What I do recall is that my expectation was that the APPG would have the opportunity to raise its concerns as part of that process. As I say, I specifically asked officials to ensure that that would be the case. And I would logically expect if there was any issue that the APPG felt wouldn't be or wasn't being addressed, that they would not be backwards in coming forwards on that. They were a very vocal group.
Did you have any idea yourself on what matters ADB would be or would need to be amended or clarified?
No, I didn't look to preempt a process that is by its nature a technical one and in which I don't have expertise.
Well, were you not interested?
The point of having a process, to my mind, was to determine what amendments should be made. I wasn't going to say, as effectively a layperson in respect of the detail of the document, these are the things that I expect to see at the end of the process. What I would expect, and that's why there are discussion papers and consultations and opportunities for stakeholders to engage, is that if there were omissions, that would be raised as part of that process. At that point, the Minister, if it was me, still me at that time, it would be me, but whoever it was, would have the opportunity to consider why the process had rejected anything that stakeholders raised and thought ought to be included, including the concerns of the APPG.
Were you not concerned, though, given the advice that you'd been receiving from your officials, which was that, or to the effect that Sir David's concerns were perhaps overstated because things were working well statistically, that these specific technical issues might not receive the anxious attention that they deserved, and that your officials might perhaps be at risk of underestimating them?
So I don't recall having that concern at the time, but the process would be such that stakeholders, including, of course, the APPG, would have the opportunity to take part in it. As I say, I'd asked for specific attention to be given to the APPG because of the discussion and engagement I had had with them. And therefore, I would expect that if issues arose as part of this process of review and discussion and consultation that stakeholders felt were not being acted upon, that would be drawn to my attention.
So you were, I'm getting the impression, and please correct me if this is wrong, that you regarded yourself as really reactive, both to what stakeholders told you and what your officials were telling you, and would make a decision as and when you needed to, based on what was put on your desk.
I don't know whether that's an accurate characterisation. Insofar as this process is concerned, I expected a process to be undertaken that would, in an appropriate and structured way, allow interested parties to make submissions, and for those to then be taken into account. And my understanding was that, given the APPG had raised a range of issues with me, they would be engaged with, and indeed I gave instructions to that effect. I wanted it is not necessarily a proper way to make policy to have informal meetings with ministers and for policy to spin out of them. What is important is that where legitimate concerns are raised, processes are followed that allow those concerns to be considered and amendments made where they should be.
Right.
I felt that was what was proposed here.
Did you not think at the time that 6 people had died at Lakanal? As a result, there was this process, whatever it was, long or short, thin or fat. There were specific technical issues. You, as the minister in charge of this portfolio, ought to keep proactive tabs on what the technical issues were, so as to make sure that whatever ever changes may be made in due course, whatever happened at Lakanal could not be repeated.
My understanding was there was a process of review. I was convinced by the advice I was given that this was the right way to undertake that, and it seemed appropriate to me, therefore, to follow that advice. And as I say, insofar as additional concerns were raised with me, I asked the team to pay special attention to those raising those concerns to ensure that they were taken into account and acted on in an appropriate way. Right. I didn't want to preempt that process.
Did anybody ever tell you, at this time or any other during your being in post, that there was at least one matter in respect of which clarity was needed, namely whether the current guidance clearly effectively banned panels with a combustible core?
I don't recall being told that, no.
Did anybody ever tell you during your ministerial role that there was in your own department the knowledge by April 2016 that there were possibly many high-rise buildings out there in our country with such cladding panels on them, namely panels with a combustible core, which the guidance back in 2006 had intended to ban, but which had not or might not have been understood as such?
No.
Let's move into January 2016, next letter, CLG 1000782. This is a letter from you to Sir David Amos of the APPG in response to his letter of the 1st of December we've seen. Now, we know from other evidence that this response, although it's not dated, was sent on the 6th of January 2016. Would that be about right?
I would think so, yes.
If we look at paragraph 2, you say this, and again, I apologise, your signature appears at the bottom. If we could just scroll down, so we could just make it clear to everyone that it's your letter. Can we scroll down to the bottom of the page? Thank you. Now, let's look at the second paragraph. You can note the first paragraph, of course, but look at the second. As I said when we met, I hope to set out the government's intentions regarding building regulations in the new year. I think I made it clear that a key objective in anything we do will be to simplify the regulations wherever possible, to reduce the burden of red tape on industry whilst ensuring public safety. Now, that wording is very similar to, if not identical, to Mr. Martin's note to you, the briefing note, on the 24th of November 2015, ahead of the APPG meeting on the 26th, isn't it?
Yes.
Yes. Why didn't you reassure Sir David that the review of ADB would address the specific concerns raised by him in his 1st of December letter, concerning in particular the increased quantity of combustible material in modern buildings?
I don't know why I didn't include that in this letter, but I thought, and certainly in the meeting and generally in discussions that I would have with any member of the group, being clear throughout that I wanted them to be engaged and they would have the opportunity to raise those concerns. That it's not in this letter, it isn't. The letter could be more fulsome, but it doesn't detract from the facts as I recall them, which is I was clear throughout with Sir David and the APPG that they would be involved in this process.
Well, they've raised their specific concerns. They've taken the trouble to set them out across at least 2 pages in detail. Why did you not think to respond in kind and tell Sir David that the specific concerns about cladding, external fire spread, the increased quantity of combustible material in modern buildings, the use of modern methods of construction would specifically be identified, and give him that reassurance?
As I say, it wasn't in the. It's not in the letter. It doesn't mean that I didn't feel the reassurance had been given, but this is the letter that was put to me, and I accepted it and signed it.
Well, that's it, isn't it? You accepted it and signed it, but did you not apply your mind, before you put your pen on it, to whether or not it really did deal in an upfront, candid and proper way with the concerns that Sir David had taken the trouble to identify?
Well, I felt the assurances that I had given Sir David and continued to give the group throughout my time there, and the instructions that I'd given officials to engage with the group and ensure they were part of the process that was being planned, would ensure that their concerns were raised in the appropriate way. I didn't want to, or wouldn't want to, preempt the outcome of an appropriate and quite technical process involving engagement with a wide range of stakeholders for improvements that could then come from it. This letter could have been longer, I think that is true, but I don't think it detracts from the reality, which is that I had every intention of ensuring the group was properly engaged with.
Why did you continue with the same line that we had seen before, which was that the key objective was to simplify the regulations where possible, to reduce the burden of red tape whilst ensuring public safety?
Well, it says a key objective, so I don't think it's exclusively saying that's the object. It's the line that was in the letter that was put in front of me, and I didn't think it was necessary to change it.
Why not? Why not, given that there are specific matters about life safety on the page, which one might think would require the government, being you, at least to check, to clock, so that Sir David would at least know that his message in those specific respects had been understood?
Because the assurance that I had conveyed to Sir David was that I wanted them to be part of that process and would ensure that they were whilst I was in post, and I had given instructions to that effect. So the way that I proposed to address the concerns that Sir David raised was to give particular prominence to the views of the APPG as part of an appropriate process, which would result in amendments recommended by people who had the technical expertise and knowledge to make those recommendations. I didn't think it was for me to necessarily preempt that process, and as I say, when I look at the correspondence now, it is I think, shorter than it ought to have been, but I don't think it changed the facts of the matter, which is that the way in which I wanted to address the concerns, in line with the advice I'd been given from officials at the department, was by a review process in which the APPG would be involved.
Yes, you said that a number of times. My point is really that, of course, they may be involved, but why not give them the assurance that of the specific matters?
Ask that question.
Well, did you appreciate that the simplification of the regulations wasn't the APPG's concern?
Yes, they had other concerns, but nonetheless, my understanding was that they would be taken into account as part of the process that had been agreed.
The way it's put in this letter, where, to simplify the regulations wherever possible to reduce the burden of red tape on industry whilst ensuring public safety. How did you read that before you signed it?
I don't recall now how I read that at the time, but I do recall my intention throughout, which, as you've observed, I've set out now a number of times.
Does that tell us about your government's priorities, namely to cut red tape whilst ensuring public safety, as opposed to ensuring public safety regardless of the regulatory burden?
I think that would be to read too much into this letter.
What's the relevance of reducing the burden of red tape on industry there, then?
I think that's generally a good thing to do where it can appropriately be done. I think it may, and now I'm in danger of speculating, which I don't want to do particularly, but in line of the discussions we've already had, it may give an insight into a thought process from the person who wrote this letter, which, as you say, may have been an issue within the team within the department. But my view throughout was that I never felt that reducing regulatory burden was going to prevent us from doing anything that we ought to do, and I felt that there was a plan in place in order to do, in an appropriate way, engaging with interested parties to undertake the changes that were needed to update the guidance.
Let's go then into February 2016, CLG 1008064. This is the APPG's letter to you of the 1st of February 2016 in reply to your letter of the 6th of January. Second paragraph down, your letter was tabled at the group's last business meeting on 26th of January, attended by 13 peers and members of Parliament, where there was unanimous dejection with the response given to the legitimate concerns which the group had properly raised with you. And it goes on, the group acknowledges that a key objective in anything government does will be to simplify the regulations wherever possible to reduce the burden of red tape on industry whilst ensuring public safety. And then he says this, it is the phrase, whilst ensuring public safety, which is the greatest importance to the group. So far, we are only seeing the emphasis on simplifying the wording of the regulations, but ignoring what the fire and construction sectors are telling you. that the existing guidance is in need of change and that there is evidence that the present problems in the built environment may be compromising both life and socio-economic safety. And then he goes on, I would reiterate again that today's buildings have a much higher content of readily available combustible material. Examples are timber and polystyrene mixes in structure, cladding and insulation, with internal fire protection usually afforded by layers of plasterboard and use of fire-stopping padding. And if we go over the page, at the second paragraph down, he says, images of these problems frequently appear on our television screens, and the solution has to be more than just simplifying the wording of the regulations. This post-empts, if you like, a question I asked you about 5 minutes ago, so forgive the repetition or apparent appearance of it, but did you appreciate what the APPG were telling you here? That there were live problems in the built environment which might be compromising life safety?
I mean, yes, that is it's evident on the face of what they've written that was the view that they were conveying.
Yes.
In the position that I had did not have large groups of organisations or bodies saying this to me. I think at the time it was effectively the APPG that was driving this concern. And nonetheless, I wanted to ensure that was taken fully into account. And as I say, I felt that we had a process by which that could be done.
But the process you told him about, as we've seen, and I don't want to go over old ground, is one of simplification where possible. Here he is telling you that won't do. Did you understand that? Did you take that on board?
I didn't take that view. My view was that it included amendments, technical amendments, and that there would be a proper discussion with and consultation with stakeholders, including the APPG. So I would expect that process to take into account the concerns that the APPG was raising.
Right. Let's see the response then. CLG 100086061. This is you back to him, 14th of February 2016. Again, undated, but we know that's the date from other evidence. Looking at the second paragraph, you say, I'm sorry to hear that the group was unhappy with the content of my letter, and I hope that I will convince you otherwise as we progress. How was that response adequate? Did you think at the time to address the APPG's concerns?
Well, as I reflect on it now, I think it is rather more curt than it should have been. But I think it reflected a frustration on my part that I felt that there was a proposal on the table that would address the concerns of APPG, as I'd said. I had, following the meeting with them, specifically instructed officials that I wanted them to be part of that process and had reassured them that would be the case. And I felt, therefore, that the letter they sent me was premature in that they hadn't... If they'd come to me and said the process has started and it's not addressing our concerns, I would have liked to think I would have a different view. But at this stage, I thought we had a plan to address it, and that therefore the letter from the APPG was a little bit premature, and that was the response that was sent, because I think it reflects a frustration that I had, that I felt that they hadn't appreciated that my intention was to ensure that their voice was part of a process that would hopefully resolve their concerns.
Did it occur to you at the time that their failure, as you saw it, to appreciate your intention to ensure that their voice was part of a process, was derived from the fact that you hadn't engaged with the specifics in their letter or letters on more than one occasion?
I don't recall exactly what I thought they knew at the time. I would, though, add, and again, I don't want to misremember things that took place. I want to be very clear that I don't have detailed notes of engagements with members of the APPG, but written correspondence to the department is not the only way that members of Parliament engage with colleagues. You have discussions and you have other sort of either whether it's a cup of tea in the parliamentary tea room or a brief chat in the lobby. The engagement that I had, particularly with Sir David, who I knew well, was not purely through the medium of formal letters through civil servants and through the department. And I think that I felt at the time that he knew that that my intention was to ensure they were involved in part of this process, and I was therefore a little frustrated at the tone that the APPG was taking in formal correspondence.
Did you have tea room or other informal conversations with Sir David on this subject outside the scope of this correspondence?
I certainly had informal conversations with Sir David. I don't want to give the impression they were regular, but it's something that on more than one occasion we discussed. And again, it would be brief, We didn't sit down and have formal meetings about it. But not just with Sir David, but the APPG generally, I thought that they understood what my proposal was and therefore was irritated by the tone of the letter that was received.
Right. Did you go to your officials and ask them about the detail he was referring to? For example, what was on television? What's all this business about polystyrene mixes in cladding and insulation?
I don't recall specifically having done so, no.
Why is that?
Well, because I felt that there was a plan in place that would properly address the concerns that were being raised.
Let's go to the next one, CLG 30193334. Sir David's response to you, 22nd of February 2016, in response to your 14th of February 2016 letter. Bottom of the page, if we can. Your 6th January letter said you hope to set out the government's intentions regarding building regulations in the new year, and as we are already well into February, some further clarification very soon would be extremely helpful, given the many assurances previously given by former ministers and secretaries of state in this regard. That's what he says there, and he refers to many assurances. Now let's look at your response to that. That's at CLG 30193335. That's dated the 7th of March 2016, or at least it has a stamp to that effect, and we can see your signature at the bottom. And this is the signed version to Sir David Amess, and you say this in the first paragraph. In the second line, I assure you that they will be given proper consideration in due course. And in the second paragraph, I'm not yet in a position to set out our plans for building regulations. It is important to recognise that fire safety is just one element of the regulations and the building control system. There are other pressures on building regulations, and I think it best to consider them all in the round. What did you mean when you said that fire safety was just one element of the regulations?
Well, I mean, that is the case. The regulations cover a wide range of things. I remember that, for example, the debate in my time there included low-carbon, zero-carbon homes. There were issues around the requirement to simplify, which would benefit fire safety, but also other parts of the work. But I think the important part of the message to that is that the view that I had taken, which I hope I've been clear about throughout, is that a more comprehensive piece of work, taking into account everything, would have a better outcome, including on the issue of fire safety, but that it shouldn't necessarily be done in isolation, because that's not the right way to amend these documents, and that was acting on the advice that I'd be given.
Right. Whilst there may have been other pressures on building regulations, of course, as you, I think, recognise, this was about fire safety and therefore life safety. What could be more important to any government than life safety?
I don't disagree with that, but my view is, and my understanding it was and is, that if you try to make amendments to one small part without considering the entirety of what you're doing, you won't necessarily have the effect that you intend. And that makes sense to me. If you're going to amend a technical and complex document, you have to do it properly and comprehensively. I understood that to be what was proposed. And my intention was that the concerns of the APPG would be part of that process and properly addressed where appropriate as a result of it. And indeed, I would, even looking at this letter, and I appreciate again it's a short letter, which if I were to be there again, I would probably request a much more fulsome response. But nonetheless, I've, in manuscript in my pen, underlined that I've instructed officials to ensure that the group is kept informed of developments. My intention was to involve the group in this process because I wanted the things that they had raised with me to be addressed in an appropriate way.
Yes, and whilst what you've just said is entirely rational, one might think, as a matter of fact at the time, did you ever ask your officials to explain to you what it was about the necessary changes to approved document B relating to life safety that couldn't be done in isolation, or perhaps those which could be done in isolation in advance of the rest, and explain to you precisely why they couldn't, as opposed to the general idea that, well, if you're going to make changes to an approved document, it has to be a holistic exercise so as to avoid unintended consequences. Did you actually ever ask anyone to do the work?
I don't I don't recall whether I asked that question in those terms, but we had been through the process reflected in some of the submissions that we'd seen, where in meetings that I'd had with them, they had explained to me that that was the right way to do it, and I'd been convinced by the answers that they had given.
Right. Mr. Chairman, is that a convenient moment?
Yes, I think it is. Thank you very much. Well, Lord Wharton, we'll have a break during the afternoon. We'll take it now. We'll come back, please, at 3:30. And as before, please don't talk to anyone about your evidence while you're out of the room. All right?
Thank you.
Thank you very much. Would you go with the usher, please? Thank you, Mr. Millett. 3:30. Would you ask Lord Wharton to come back in, please? All right, Lord Wharton, ready to carry on?
Yes.
Thank you very much.
Thank you.
Yes, Mr. Spillett.
Yes, thank you very much, Mr. Chairman. Can I ask you to look then, finally, on the subject of the APPG correspondence at CLG 3030840. And I'd like, within that document run, please, to go to page 7. Now, what I'm showing you here is a briefing note written immediately after the Grenfell Tower fire by Simon Ridley, who was the Director General for Decentralisation and Growth for Helen McNamara, who had taken over as Director General for the department from Peter Schofield. And what Simon Ridley says in the 4th bullet point down, this is after a review of the APPG documents. The 2nd bullet point, I'll show you first. The lack of urgency or reason for the delay is striking. Most telling is David Amos's letter of the 10th of September 2015, which explicitly states the APPG felt ADB issues, quotes, had significant life safety implications, quotes, and, quotes, are of sufficient priority to be dealt with immediately, close quotes. And the Minister is said to have not been willing to bring work forward. James Wharton's 13th October letter is clear a detailed work plan had not been agreed at that point. So we look like we've done all but nothing in the first 2.5 years. Focus on red tape very clear. And then in the penultimate bullet point, the APPG provides warnings on cladding and combustibility and more generally issues with modern materials, etc. We never acknowledge this as far as I can see, either to argue against or address. It isn't covered as an issue in any advice or drafts of the various draft reviews / consultations in recent months. Now, just pausing on that bullet point there, is it correct as a fact, first, that government, or you, when you were a minister, never did acknowledge cladding and combustibility and more generally issues with modern materials back to the APPG?
In the correspondence with the APPG, I think that is correct.
Right. And is it correct also that it wasn't covered in any advice or drafts of various draft reviews or consultations that you had seen either?
There were other, so for example, I remember Julian Brazier MP raised an issue which was to do with combustible materials on modern methods of construction. It was a wooden construction building, and I had a meeting with him about it. So it did come up during my time there, but I don't recall us having sent any documents to the APPG regarding that.
Yes. And in the last bullet point, Mr. Ridley says, our correspondence with the APPG is appalling, delayed, partial, and looks chaotic. Would you accept that criticism?
Not necessarily in those terms, but as I've already said, I think that it could have been more fulsome and more clearly addressed the issues. I did feel that we had proposals in place to properly take into account of the concerns the APPG had raised, but no, I would accept the correspondence was below the standard of engagement that should be expected.
Now, I want to turn to the topic of delay in publication of the BRE research. Can we start here on this with your first statement, please, page 9, paragraph 21. And you say there, I understand that a submission concerning building regulations and energy performance external research and implementation programme was sent to my private office on 14th of December 2015. It requested approval to publish the research, including research relevant to Part B that had been commissioned under previous ministers. I'm informed that officials sent emails to my private office chasing the submission on 3rd of March 2016, 24th March 2016, and 9th of May 2016. There was discussion between various private offices in respect of the unpublished research on 10th of May 2016. I do not recall being aware of this submission. Had I seen it, I would have considered it a routine matter to approve it and would have done so without hesitation. Now let's look at some of this. First, please, CLG 30193347. Page 4. CLG 30193347. page 4. Now, this is an email dated the 14th of December 2015 from Andrew Newton to your private office, and he sends a submission attached to it. He says, "Hi Sarah, please find attached submission that is seeking ministerial approval to publish a series of historical research reports from work carried out under the coalition government. It consists of the submission itself plus a single annex. Summary, approval for publishing a number of research reports commissioned under the coalition government in line with the government's commitment to publish all research." Now, a little background for you before we come to the question. The research was commissioned in 2012, reported in February 2015, but because of purdah before the general election in 2015, and then reading in time when he became minister, no approval was sought for this publication until December 2015. That's the history. Were you aware of that history?
I don't recall having been aware of it, no.
Did anybody bring it to your attention?
I don't remember having had this brought to my attention, no.
Did you know that the research was the recent research that you'd been told in the 15th of September 2015 submission that we looked at before, that identified a number of technical issues which required attention in order to protect life safety?
No.
You didn't? Right. Can we turn to the submission itself again? CLG 1000840. I'm sorry, I say again, I think you haven't seen it yet. Here it is, 14th of December 2015, from Andrew Newton, cleared by Bob Leadsom to you. The recommendation at 3 says that you agree that the enclosed research reports are published in line with the department's commitment to publish the results of all research carried out. 4, under background, the Building Regulations and Energy Performance Research Programme is designed to provide evidence to inform decisions on changes to building regulations, standards, and the building control system. And then at paragraph 5, under the heading Publication of Research Reports, a number of reports from research projects commissioned under the last government are now ready for publication. Summaries are below. And then you can see under that 7 topics under the heading, under different headings. So sound insulation criteria, that's approved document E. Toilet provision, approved document G. Fire compartment sizes, B. Approved document B over the page. Investigation of real fires, approved document B. Fire safety procedural guide. Hot water safety risks. Domestic security standards, which is Q. Accidental dwelling fire casualty profiles. And assuring the safety of electrical installation works in dwellings. And then at paragraph 6 it says this: more detail on the scope of each research project and key findings from the reports are provided in Annex A. Copies of the full reports can be provided if the Minister wishes to see them. Now, these 7 topics are referred to, or were referred to, as the 7 work streams. Were you aware of that?
I don't think so. I don't recall having been so.
Right. Now, we've heard evidence before, for example, from Bob Leadsom on day 241 at page 197, that the submission of the discussion document to set the scope of the review of the building regulations and approved document B was dependent upon the publication of this 7 workstream research. Did you know that?
I don't recall having known that, no.
Right. He told us that these 7 workstreams were to feed into the full review of ADB, depending on what they recommended or suggested. Did you know that?
I don't recall having known that, no.
He also told us that it was certainly a worry, his words, that without publication of those reports, any work on review of approved document B couldn't be progressed. That's what he told us at day 241, page 196. Did you know that?
No, I don't recall having known that.
Right. Now, it was Richard Harrell's evidence, and that's para 65 of his witness statement at page 20, that these final research reports remained important in being able to launch the Part B technical review. Did you know that?
I don't recall having been aware of this issue or these documents.
No. Although he did say in his oral evidence that actually the discussion document could have been taken forward without the publication of the 7 work streams. So he qualified his evidence, to be fair to you, in answering the question. But I think you're telling us you had no idea about these.
I can't remember this being an issue that I was aware of.
So can we take it, and I apologise for repeating the question, that you didn't know that the view among officials within the department was that progressing the review of approved document B was contingent on the publication of this research?
No. As far as I can recall, I was unaware of this issue.
Can you account for why you were unaware of it?
No one had told me, as far as I remember.
I suppose that's true, but can you explain how it came about that none of your officials did tell you?
Not without speculating. I have no knowledge of facts as to why that was the case.
Ought they to have told you?
Looking at it now, it would appear yes, certainly.
Right. Now let's go to CLG 3019347. This is an email of the 3rd of March 2016 to all PS advisors. At the top of the page. I'm so sorry, I apologise. We want page 3 of this email run. There it is, Andrew Newton, 3rd of March 2016, to all advisors. Subject, forward, agreement to publish a number of historical research reports, submission and annex. Any news on us being able to publish these reports, question mark. Now, this would have gone to your private office, I think, wouldn't it?
Yes.
Yeah.
Actually, I'm not sure. I don't know whether all advisors would include my private office.
Oh, right. Who would it include?
It might be the special advisors.
Right. Would it find its way to you or your
if somebody sent it, but I don't know whether all advisors would include anyone in my private office. If it went to the special advisors, then, I mean, they might share it with my private office, but I don't know.
I see. All right. Now, the email is from Andrew Newton, and he's asking about the 14th of December 2015 submission and whether there was any news on being able to publish. If you look at the 3rd paragraph down, he says, while I know that they are very much non-urgent and far from being a priority, it would be good if we could start getting them published because there is likely to be PQs about unpublished research before too long, which will be much easier for the department to answer if we've at least started the process of getting the position up to date with all this historical research. Now, do you recall seeing this document or knowing about it at the time?
No.
Do you know why Andrew Newton is saying that the research is very much non-urgent and far from being a priority?
No.
No. It is, would you agree, completely inconsistent with the importance attached to the publication of this research by officials in the Building Regulations Division as told to the inquiry in their evidence?
It would appear to be. I suppose you could make the argument that I don't know how long they need to have been published before you can start the work, so you could perhaps time the two. You could prepare everything and these could come out in short order before that the discussion document was released, but I don't recall having been aware of any of this discussion. Was
there a view in government, to the best of your recollection, that research commissioned by the previous coalition government was unimportant or had no connection with current policy?
That was never communicated to me if it was the case. Right. If you would like me to, I can speculate, but I don't know factually what happened at this time.
Right. Let's then move up the string to the top of page 3. There's another email, this time the 24th of March, from Andrew Newton to all advisors. This time it's copied to Brian Martin, Nick Price, Richard Harrell and Bob Leadsom, as you can see. So this one would have come into your officials, or did in fact. Advisors, is there any news on when we might be able to start publishing these, please? As I said in my previous email on this, see below, I fully appreciate that this clearance process is far from being a priority, but we now have our first FOI in relation to them requesting access to the findings of the report on Part E, sound insulation. We're working with the FOI team on the best way to respond, which will probably need to be something along the lines of it being prepared for publication shortly after recess. This makes it quite important that we start publishing these in April, both to ensure we meet any commitments given, but also so any future queries on these reports will be easier to answer. Again, do I take it that you weren't aware of this email?
As far as I recall, I was unaware of this, yes.
Right. Was there anything in practice stopping any of those copied into the email from contacting your private office and telling your private office, and thereby you, they would hope, saying to you, well, look, Mr. Newton is wrong. This is a priority. We need this research to be published because without it, it's holding up the review of ADB.
I'm not aware of anything that would stop them contacting my private office.
And similarly, could they, in practice, have contacted you directly? bring it to your direct attention?
It would be highly unusual. Most engagement between a minister and the department goes through the private office, but in, for example, individual meetings, it could be raised, yes.
Right.
And I mean, they could raise it directly, but that would be, I suspect, stepping outside of agreed procedures.
And do I take it that in individual meetings, they didn't raise it with you?
Again, I have no recollection of this issue being raised.
Now, moving up the thread again, if we can, please, to page 2. You can see that at the top of page 2, under the Great British Coast graphic, there's an email from Andrew Newton, 9th of May 2016, copied to, among other people, Brian Martin and Richard Harrell, sent to all advisors. And he says, "Dear Omar, I'm sorry to ask about these again, but as you can see from the below email, people are starting to ask about unpublished research again." And then he continues in a similar vein in the third line, "As of themselves, I recognise that clearing historical research reports for publication are not necessarily a priority, but both of these factors now make it quite important that we start publishing these in the next few weeks. If nothing else, pulling together a response to the sense about science interest in this will be much easier to complete if we've started to bring the position more up to date." Now, again, can I take it that you weren't aware of this email either?
You can, yes.
So you can't explain why Mr. Newton is, for the third time now, taking the position that the publication of these is not a priority?
No, I can't.
No.
It seems to have broadened out to a larger group of recipients, would be my only observation, including Mark Francois, the Ministry of State's private office,
Right.
but not mine.
We've previously discussed the screening and triage process for submissions. Do you know whether this submission was a victim of that?
This isn't even yet a submission, from what I can see.
Right.
I mean, it may be that would have been a way of raising it if it had been compiled as a submission and submitted to a minister. But
And then if we go to the top of the chain, page 1, there's an email of the 10th of May. To all advisors, from all advisors, to P.S. Marc Francois and your private secretary, and also all advisors. Lucy, Sarah, there are a number of historic research reports. A lot of them are in the building regulations space. I got an email from Richard Harrell about this on Friday, and I'm in the process of trying to manage putting them out. Jacob clearly has an interest from a comms perspective. I'm asking for a list of all outstanding reports from the coalition government, but there are some potential issues here. I will come speak to you both. Thanks, Omar. And Omar is Omar Elahi, who was Lord Heseltine's private secretary. That email went to you, it looks like, or your private office at least, yes?
to my private office, yes.
Yes, and that's at the top of a string which includes the 3 emails from Andrew Newton, 3rd of March, 24th of March and 9th of May, all about the publication. Are you sure you didn't see this at the time?
I have no memory of seeing this.
No.
I wouldn't see generally emails that are sent to my private office. I mean,
Right.
that would not be normal for me to see their inbox.
But this was relevant, though, wasn't it, to something which was squarely within your responsibility, namely the ability to get on with approved document B.
It would appear to be, yes.
Yeah, so can you explain why it is that your private office, having received this email string and identifying one thing which was holding up the getting on with that exercise, not brought to your attention for your action?
I can't, no. So as far as I can remember, I was unaware of this. I don't know whether it's accurate to say this was holding up the process. Because, as I say, it may be that this is something that could have either been done very quickly and then and not therefore held up the process if the need became that pertinent, or indeed I think there was some indication earlier that the process could be undertaken without these, although it wasn't the ideal route. But I don't recall being aware of any of this at the time.
But this related to the 14th of December 2015 submission, and if it was put at the bottom of the pile, can you explain how that happened?
I can't. As I say, I was unaware of this issue. As best I can recall, I don't have any memory of being aware of this issue. And when I looked at this, as I commented in my witness statement, it seems an entirely routine thing to me. I don't see why there would be a concern about. I can see why there would be a concern in theory, potentially, about publishing documents that had been commissioned by the coalition, and why. And I see this refers to Jacob, who would be Jacob Wilmer, who was the special advisor who primarily looked after media relations and comms for the Secretary of State. So I can see why he might want to have a look at things that were being published for fear that something that could cause embarrassment or not be in line with where the government's position. But I don't see why these documents would be likely to do that. And I don't, if to be entirely honest, understand why, if this was an issue, this wasn't escalated.
Does that point to a serious administrative error in your office?
It would appear this only came to my office towards the very end, but certainly this is something that, had it been brought to my attention, I would like to think that could have been very quickly resolved.
Indeed, but does the fact that it wasn't not point to a serious administrative error or oversight in your office?
Well, on the limited facts that I have, I don't want to make a judgment about the administration of my office, which my experience of it was that it was professional and ran well and did a good job for me in my time as a minister there. It appears that something has gone wrong in this instance, but it also appears that my private office, at least, was only involved in the very latter stages of this series of correspondence.
Yes. Well, I mean, that may be enough. You accept, I think, that something has gone wrong in my office. I'm just asking you to accept that. I think you do accept it.
Yes, I think this should probably have been escalated to me, and it could have been resolved. I didn't see it. I suspect what lies behind it is a comms concern, and that itself sat outside of my office. And the issue here is how it was interacting with things that the department needed to do outside of the narrow comms consideration. Mm. But that is my interpretation of it. As I say, I was unaware of this at the time.
Was there any sort of system in place for tracking submissions and making sure that they didn't fall through the cracks?
I would assume so. I'm not familiar with exactly how that would work, but I don't see, and it's one of the things that strikes me as unusual about this series of correspondence, is that at no point does it appear to have become a submission.
Was there any consideration given to the fact that your office may have been part of the hold-up, sitting on a ministerial submission which was delaying the review of ADB?
Well, I wasn't aware of it, so it's not a matter that I would have considered at the time.
No, all right, but the system of which you were minister was essentially holding up the review of ADB.
I mean, it strikes me looking at it that this is something more to do with the special advisors for whom I had no responsibility. But if the point at which it came to my office, had they appreciated that this was an important issue, I would expect it to have been raised with me, and it wasn't. Beyond that, the more general cause for this problem seems to sit outside of my office with something else that was going on in the department.
Was there an internal mechanism within the department or within your office for making sure that the reasons for the hold-up, as we can see from this email run, wasn't a bottleneck at ministerial level?
This looks like a bottleneck at special advisor level to me, but I'm not aware of what process was in place. I don't see any evidence of a bottleneck at ministerial level here.
Well, there is a bottleneck, isn't there, at ministerial level, in the sense that the submission had essentially said that there was going to be no progress on the ADB review until the publication of the research, and that hadn't happened. And so your department couldn't deliver on the promise to the coroner without the publication of the research. Isn't that a bottleneck at either your level or certainly within your department?
Well, it's within the department, but I think that, and my interpretation of this, and as I say, I wasn't aware of this at the time, is that the hold-up appears to be in getting approval from special advisors for the release of these documents. So what I would take from this is, which is, in principle, doesn't surprise me as an interpretation of what might have happened, if I might, Mr. Chairman, I don't know. It would appear to me that the special advisors have said, we want to check everything before it is published, which is understandable from the coalition time, which is understandable. We want to see what's going out. And as a result, things that they haven't checked and approved have not been published, and the bottleneck would appear to have been in getting that approval at that level. What strikes me about this is at no point did anybody compile it in a submission to me to either say, there is a problem here, this needs to be unblocked, can you make a decision, or even to make me aware of it. And again, I suspect because the point at which there was a hold was it needed to be approved by the special advisor before it would then go in a submission for me to make the decision. And I'm not saying that should have happened, it certainly shouldn't, but it's something of which I was entirely unaware, to the best of my recollection.
Well, let's just go to CLG. Let's go to CLG 1000840. This is the submission for the. We looked at this before, didn't we? Do you remember?
Yes.
Yes. That's why I was referring to the 14th of December 2015 submission, and about the reports. Now, this had come from Andrew Newton to you directly. Yes.
I don't know whether this came to me. I mean, this was prepared.
Well, it's addressed to you.
Yes, but I don't know whether I received it.
Oh, did you not?
I don't know. I don't recall. I don't recall having seen it. I mean, I saw many submissions. It's possible that I just don't recall. But given the routine nature of it, I would have thought, if I had seen it, I would have approved it, and then I would expect the publication to take place. I wonder whether, therefore, if that could well have happened, but in which case I don't recall it, or I wonder if it ever reached final form and went into my box, as it may have been waiting for approval from the process we've just seen an email chain about before it could go into my box.
Right.
I can only apologise. I don't have a clear memory of this, and when I read it, even if I had seen it, it looks routine and straightforward, and I don't see why it would stand out. What comes as effectively news to me, which I didn't know at the time, is that there was this series of email correspondence going on, which I was not aware.
Yes.
Well, presumably we can be fairly confident that it got to your private office, can't we? Because it's addressed to your private secretary.
I honestly can't say, Chairman. I mean, all I can say from this is that a submission was drafted and prepared. Whether it actually went to my private secretary, I don't know. And whether my private secretary then waited for whatever further approval process, which was the bottleneck we've been looking at, or it didn't get to my private secretary until that bottleneck was cleared and it had been prepared in draft, I can't honestly say. I just don't recall or wasn't involved.
All right. Thank you.
Sorry.
No, that's right.
Right. We've heard from a number of witnesses. We've heard from a number of witnesses on the subject of the publication of the 7 work streams reports. And this was expressed in a number of different ways by various witnesses here, that the sign-off for publication of this research not being given was a considerable source of frustration, both to Mr. Martin and to Mr. Harrell. That's day 241, page 198, line 70 to 22, just for our record. And there are various others. Did you have any awareness at the time, so March, May 2016, of the frustrations felt in the Building Regulations Division in trying to progress the ADB review?
As I say, I can't recall having been aware of this issue at all. And when I look at it, I can't envisage why, had this been put to me, this wouldn't have been a very straightforward thing to deal with.
Well, indeed. Do you accept that it shouldn't have been the way it was, and that the requests by those officials for authority to progress policy matters should have been dealt with in a timely manner?
Yes.
And that your office should have been accessible to them to get this work done?
Yes, although when I reflect on the email chain, it appears my office was only involved towards the end of it, which makes me think that, and again, it's speculation, I don't know, whatever the issue was, sat elsewhere than my office. Now, could my office have potentially resolved it by drawing it to my attention when they became aware of it? Possibly. But I think that the issue itself sat outside of my office, judging on the limited information I have and the fact that I wasn't aware of it.
We've also heard from Richard Harrell and Bob Leadsom at various points in their evidence that they were experiencing a sense of frustration in the period 2015 and 2016 because of the low priority in the department accorded to the ADB review, and they always felt that they were, as it were, at the back of the queue. That was their evidence. Did you ever get a sense of that feeling or sense from them?
No. I mean, we've seen, and I think as you have heard in my evidence, if anything, I had a frustration at the time it was taking. I don't recall anyone turning around and saying to me, this is because of some other reprioritisation of which I was not aware.
Were you ever made aware that the anxiety and frustration within the Building Regulations Division was having the effect that some of the members of staff were so stressed it was making them ill?
No.
Are you able to explain why it was that when the department, in the shape of Brian Martin, was told in February 2016 by an industry player, Booth Murray, that aluminium composite material polyethylene cord products were being routinely used on high-rise buildings in the UK, that fact was kept to Mr. Martin, not accelerated to Mr. Harrell, not accelerated further to Mr. Leadsom?
No, I don't recall having been aware of that at all.
No, indeed. Can you explain why even you weren't aware of that?
I mean, ministers don't manage the HR of the department. I would expect the team to be run in an appropriate way and appropriate things to be brought to me. I don't have a mechanism for being aware of things of which I am not aware.
Are you responsible for the escalation system in your, and the supervision and monitoring system in your department?
Not directly, no, I wouldn't think so.
Right. Who is?
But ultimately, the Permanent Secretary.
Right. Do you accept, looking back on it now, that you ought to have been told that within the UK built environment there were potentially a significant number of high-rise buildings which are clad in aluminium composite material with a combustible core?
Yes.
And that was potentially as a result of a legacy of either absence of any regulation at all in ADB by way of guidance or guidance in ADB which was unclear, open to interpretation and misleading?
Yes.
Were you aware that the Building Regulations Division had been experiencing acute problems with the recruitment of senior professional technical officers?
I don't recall having been,
Right.
no.
Did nobody tell you that those roles had been phased out over time and that by March 2016, in effect, they were down to 5 grade 7s instead of 4 grade 7s and 4 SPTOs instead of 8?
No, I don't recall being aware of that. And again, my expectation is that is something that would be dealt with by the civil service rather than ministers.
I see.
However, had something like that been drawn to my attention, clearly it would have been something I would have raised.
Right. Who would you have raised it with?
Probably the Permanent Secretary and the Secretary of State.
Right. So you didn't know the department was struggling to recruit people with the right skill sets and the depth of knowledge to be able to carry forward the work?
I don't recall that having been raised with me, no.
Right. Whose responsibility would it or should it have been to ensure that the building regulation system remained up to date and in pace with industry?
Combination of the building regulations team and department, who then through decisions that I would take as a minister based on recommendations that they would have given to me at that time.
Now, Brian Martin was the technical policy lead on fire safety matters in the department. Were you aware at any time that pretty much anything relating to fire safety would go to him during the time that he was fire safety policy lead?
No.
You weren't aware of that. So you weren't aware, were you, therefore, that effectively there was no one in the department who was able to challenge him on fire safety matters or peer review him in any really profound way?
No, I wasn't aware of that. Although my understanding is that there was a team of people and I would expect there to be systems within the team to properly account for that. But no, I wasn't.
Right. Was it your experience during your time as minister that technical policy leads generally had a very large degree of autonomy, or was this an unusual case?
I couldn't honestly say. It's not an issue with which I particularly involved myself. My role as a minister was to ask for things from the department where I felt that within my policy area I wanted something, and respond to things that needed ministerial decision from the department going the other way, where they needed those decisions in order to continue carrying out the government's policy.
I see. I mean, it sounds very much, and correct me if I'm wrong about this, Lord Wharton, but structural questions and the efficacy of line management, monitoring, supervision, peer review, resourcing within the officials in your department, is this right, were a matter either principally or solely for the permanent secretary?
And the civil service, but yes.
And the civil service,
Yes.
but not for you?
But correct, that would be my understanding.
Right. And is this right? The best you could do would be to raise any problem in those respects with the Secretary of State or the Permanent Secretary and do your best to help within the confines of your responsibility as Minister?
Yes, and I think within that, if a problem was brought to my attention, I would try to address it, but that would be quite unusual.
Do you accept, looking back on it, and we've looked at quite a bit of evidence today, that neither you nor your private office ever really engaged with the detailed substance of the work of the Buildings Regulation Division?
No.
You don't accept that?
No. My feeling at the time was that a number of issues had been raised, and there was a sensible plan which took into account the advice I was given to address those issues.
Yes, that answers, of course, a general one. But can you give me an example of an area of detail, substance of the building regulations or the approved documents which you familiarised yourself with, took an interest in?
I mean, from the best of my memory, there was the example I talked about earlier with Julian Brazier, where we got into a particular issue because he had raised a concern with me. There was an issue that we worked with on the Department for Culture, Media and Sport regarding noise and issues around it overlapped with planning consents for conversion of venues at the time, which we had a number of meetings about, where issues arose that required more involvement, that we would of course get more involved. There was no reluctance on my private officer's part or mine to address issues as and when they arose. The challenge here is that my understanding was that this was in hand and being addressed, and I relied on the advice I was given in coming to that understanding.
So you've given as an example in that answer Julian Brazier. Now, is that timber frame buildings?
Yes, it was, yes.
As a result of a fire at something called, I think, the Old Tannery. Is that right?
That sounds right, yes.
Yes. And he was the MP, wasn't he, for Canterbury?
That's correct.
Yes. Can we go to that? Let's look at this. CLG 3030835. Correct me if I'm wrong about this, Lord Wharton. Now, here is an email from Cherry Grant, who is from the office of Julian Brazier, Member of Parliament for Canterbury and Whitstable. Please find below the latest press release from Julian Brazier regarding his meeting today with James Wharton MP, Minister in charge of building regulations, to discuss fire safety issues after the Old Tannery fire last July. And the date is July 2016. Is this the event that you're referring to?
This is, yes, in the round, yes. I mean, this is a press release his office wanted to put out after I'd met him, but yes, it is.
And there's a press release below that about the Old Tannery fire safety shortfalls. Now, I think, as you said, this was about timber frame buildings, and the fire had destroyed 45 homes. Yes?
I don't recall the detail, but I will be correct.
Okay. And we can see from the press release, if you look at that, in there, if you look 2 paragraphs up from the bottom of the page, it says this. The Minister agreed to consider the fire safety inspection points that Clive and Stephen raised in his discussions with the industry. What investigations did you put in train as a result of that fire?
I can't remember the detail of that. My recollection was that this fire had taken place in Mr. Brazier's constituency. He was concerned about it and wrote to me. I don't recall whether there was a parliamentary debate about it or not. I can't quite remember the specifics, whether he raised it in the debate. But I received a briefing on it from the department. To the best of my recollection, the issue turned out that it was not that the construction had been not in compliance with the regulations, but there was an issue with the inspection rather than it being an issue with the regulations. There was regulations not being properly applied by an inspector rather than the regulations themselves being wrong in terms of allowing something that was that should not have been allowed. I met with Mr. Brazier. We had a discussion about it. I took that, though I informed him of our understanding of it, which he found helpful. They raised points about the inspection, and that I then reflected those back in the department, and we've touched on already there was a sort of ongoing debate around approved inspectors, their interaction with local authority inspectors, whether that system should be looked at and changed, and it was part of the consideration around that. I don't think it went significantly further than that in my time there, but it was something that when you ask for examples of being more of giving more focus to issues that arise in this area, that would be an example where I think an engagement with a colleague that the colleague found very helpful, and which I hope did inform the department's view of the approved inspectors regime.
Right. Looking back on it, do you accept that you never made comments or challenged any of the submissions that were sent up to you by the officials?
No, I would often discuss submissions with officials, and I mean, challenge can also be in the form of asking questions. I didn't seek to, if an official explained something that was technical to me, then I wouldn't necessarily say you need to rewrite this and change it, but I would want to ensure that I understood what they were saying to me and that I found that their advice was plausible, which I generally did.
Apart from asking once about the speed of the review, can you recall any occasion on which you challenged anything in the submissions that you saw on approved document B?
I certainly asked more than once about the speed of the review. It was an ongoing frustration, but I can't, going back 6 or 7 years, remember the detail of discussions that I had around it. I think, as an example, I know one of the, which we've discussed in this hearing today, one of the documents they put to me then resulted in a meeting with 4 officials whom you named. And in that meeting, I would have asked questions. That's not just signing off what's in front of me. That's wanting to understand, having those discussions, and ultimately being reassured by people on whose advice I relied.
Right. I mean, do you recall specific occasions on which you challenged what you were being told in?
I don't recall the specific questions that I asked. It's 6 or 7 years ago.
Yeah. Do you consider, looking back on it, that you allocated sufficient time to understanding in depth the issues underlying Lacanal and the wider problems underlying approved document in terms of external fire spread?
Given the information that was available to me at the time, yes.
Well, what was the information given to you at the time?
Well, you've seen much of it, and the advice that I received from officials when these matters were discussed in the briefings that I had.
Right. So the material we've been looking at together. Yep. Is there anything else you would point to that gave you a deeper, more granular understanding?
Well, the discussions around the materials. So, as I think it says, I think in my witness statement that I had probably more than a dozen meetings, for example, with Bob Leadsom, taking me through issues and ensuring that where I had questions, they were appropriately responded to, and that I was satisfied with the advice that I was being given.
Now, I just want to go back on one factual question. Can we please go to CLG 1007868? This is an email from Andrew Newton of the 14th of December 2015 to PS James Wharton. So that's your email address, copied widely around government. And it says, "Hi Sarah, please find attached submission that is seeking ministerial approval to publish a series of historical research reports from work carried out under the coalition government." And we saw the submission, but this is the email which covers it. Do you accept, looking at it, that it did go at least to your private secretary?
Yes, I think it's clear that it did.
Yes. And therefore, if it didn't come to you, that would be a serious breakdown in communications within your office?
Not necessarily. It depends on the other considerations that my office would have to take. So every submission that goes to your private office does not automatically go into your box. Your private office has a role in ensuring that whatever needs to be done, for example, in this case, and I say I'm speculating, I don't know what went on here, but if, for example, this needed to be cleared by the special advisors before it went to me for clearance, that may still be where the hold-up was. Now, I think you can make the argument this should have been raised with me if there was concern that this was being held up somewhere, to see if I could help unblock it. But not every submission that is sent to your private office is then immediately put into your box. Your private office has a role in triaging and, where appropriate, returning and asking for amendment to submissions.
But this one is asking for ministerial approval. Was it the system that your office would decide what you should or shouldn't give ministerial approval to?
They would no. My office, the private office, and it wasn't just my office. This is a normal process. The private office manage what goes into the ministerial box. So if somebody asks for ministerial approval for something, they will draft a submission and put it to the private office. The private office will then potentially ask for amendment to it if there are things that need to be clearer or added or removed or whatever. And they will then, or should then, ensure everything else is lined up, so that by the time it gets into the minister's box, because ministers get a lot of things in their box, they have to be managed. In that sense, the flow of documents needs to be managed, that it's ready to go. And so, I don't know what happened with this. I don't recall having ever seen it, but it's quite possible that if, for example, this could not be approved under the procedures that existed until the special advisors had signed it off, that rather than putting it in my box, it then went back into that system so that it was ready to go by the time it got into my box.
Sorry, my question was a bit simpler and perhaps a bit simplistic, for which forgive me. But was it the normal procedure that where a submission came for ministerial approval to your office, it would ordinarily go into your box for your approval?
I don't know.
You don't know?
No.
You don't know whether that was the system or not?
Well, I know that once a submission had been approved by my private office, it would go into my box. My private office would have a system for approving that. I mean, they have to manage what goes into a minister's box. That's normal for a private office. As I say, I don't know why. I don't recall having seen this. Most likely I did not see it, because I don't see why I wouldn't have just approved it. But beyond that, I would be speculating as to why this didn't make it to me. But I would think there would be a reason, because there was no shortage of things that did make it into my box.
Right. Well, thank you very much, Lord Wharton. Those are my prepared questions. There are one or two I know that I'm being asked to ask, which I now need to consider a little bit more closely. So can I ask for the usual
break?
Break, please.
Yes. Well, Lord Wharton, you may know this, but when Council gets to the end of his prepared questions, we have to have a short break, both to enable him to check that nothing's been left out, and also to enable others who are following the proceedings from elsewhere to suggest questions that perhaps we ought to put to you. So we'll rise now. We'll come back at 4:30. I think that'll be enough time. If not, we can be told.
Yes, all right.
Well, 4:30 or as soon as possible after that as we can, and then we'll see if there are any more questions for you. All right?
Thank you.
Thank you very much. Would you go to the usher, please? Right, Mr. Millett, if you need more than the 10 minutes I'm currently allowing, you can ask the usher to tell us.
I'm very grateful, Mr. Chairman. Thank you.
Thank you very much. Would you ask Lord Wharton to come back in, please? Thank you. Right, Lord Wharton, let's see if there are any more questions for you.
Thank you.
Yes, Mr. Villett?
Yes, Mr. Chairman. Lord Wharton, can I ask you please to be shown HOM 3019995? Now, this is a report of the House of Commons Committee of Public Accounts entitled The Failure of the Fire Control Project. I think you can probably ignore the warning in red that this is an embargoed advance copy,
Yes.
given its date, which was the 14th of September 2011. Take that from me. You can find that, in fact, on page 3, if we just look at that. And then if we go in that, please, to page 7, you can see that it says this. Summary. This is one of the worst cases of a project failure that the committee has seen in many years. Fire control was an ambitious project with the objectives of improving national resilience, efficiency and technology by replacing the control room functions of 46 local fire and rescue services in England with a network of 9 purpose-built regional control centres using a national computer system. The project was launched in 2004, but following a series of delays and difficulties was terminated in December 2010 with none of the original objectives achieved and a minimum of £469 million being wasted. The project was flawed from the outset, etc. Now, when you came in to the post as Minister, were you made aware of the fire control project?
Gosh, I don't recall, although I think I was on the Public Accounts Committee at the time of this report, so I did have some awareness of it.
Yes. Did you contribute to the report, do you think?
I honestly don't recall. It will be it will tell you in the report. We did a lot of reports. I do. This issue is familiar to me. So, well, not in detail, but I think this must have been a report with which I either attended the hearing or contributed to the report in some way, because it isn't a totally new document to me.
Right. Was it your own view that the project was an abject failure?
I'm subject to, again, this is 10 years ago or more. It was the view of the committee which I suspect I did not go against. So collectively, the view of the committee which I accepted and was prepared to stand by.
Right. What was your understanding of the reason for the project being scrapped entirely?
I don't recall. This is over a decade ago.
Right. And if you look at page 9, you can see that it says there, in paragraph 1, the department failed to secure the cooperation and support of local fire and rescue services. What did you understand the state of cooperation between the department and local fire and rescue services to have been?
I honestly don't recall.
Right. What about during your time as a minister? Was that something on your watch?
I don't think it was directly on my watch, no. I didn't deal with the fire and rescue services directly as a minister.
That wasn't yours. Whose responsibility was that during your time?
I think it would have been Mark Francois, and then I think it then followed Brandon to the Home Office. I think at some point it was merged with the Home Office, but fire service wasn't in my portfolio as best I recall. Well, I would recall if it was.
Right. And do you know why, despite the scale of failure and waste, nobody in the department was held accountable, as the report says at page 10? Well, foot of page 9, actually, and over to page 10, paragraph 5. Sorry, I'm so sorry, page 9, paragraph 5. Despite the scale of failure and waste, no one in the department has been held accountable. Do you know why that was?
I don't, but I mean, I must apologise. This is not a document I was expecting to be commenting on, and it's something that a committee that I sat on over 10 years ago. So I haven't applied my mind to what had happened with this report and this document in advance of this hearing.
Very well. Thank you very much. Lord Wharton, those are all the prepared questions I have for you, save one, and it's a question that we reserve for people involved with particular matters relating to the lead up to Grenfell Tower and its aftermath. Looking back on the evidence we've looked through over the day and looking back on your own experience at the time, is there anything as a minister that you would have done differently?
It's a difficult question to answer, as I'm sure you will appreciate, and one that I have given significant thought since the terrible events that unfolded there. And I don't want to apply hindsight to talk about things that, had we known what we know today in totality, I would have done. But when I look at the evidence and my time there, I think that I would, if I were to live it again, want to have broader engagement with interested parties and stakeholders across a whole range of policy areas. And I feel, without wishing to prejudge what this inquiry may find, that I didn't always get the full picture of concerns that were raised or issues that were raised in areas for which I had responsibility presented to me. I think that's reflected to some extent as well in the correspondence to the APPG, which I would wish had been more fulsome and engaging. So there are things that I would have done differently. And it is something, as I say, I've given significant thought to. But I'm hesitant to draw out conclusions based on the facts that unfolded rather than those that can apply in more generally to the approach that I would have taken, where I'd be put back into that role, knowing then what I know then, with the experience that I have now.
Well, thank you very much, Lord Wharton. It remains for me to thank you very much for coming to the inquiry and assisting us with our investigations. We're extremely grateful to you. So thank you very much.
Thank you.
Yes, and I must add my thanks, Lord Wharton, on behalf of all three members of the panel. It's been very helpful to hear what you have to tell us. We get an unusual and valuable insight into the workings of the department when we hear from a former minister. So we're very grateful, and thank you very much for giving us your time.
Thank you.
And now you're free to go, of course.
Thank you.
Thank you very much indeed. Well, thank you very much, Mr. Millett. That brings us to the end of today and to the end of the week.
It does. And our next witness is on Monday, when we hope to hear from Mr. Stephen Williams.
Yes, thank you very much. Well, at that point, therefore, we will conclude the present hearing, and we'll resume at 10 o'clock on Monday morning, please. Thank you very much.
Thank you.